একটু ওয়েট করো, হ্যাঁ একটু সময় লাগছে।
হ্যাঁ এখন লাইভ হয়ে গেছে ওটা ইউটিউবেরটা। হ্যাঁ 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 এই তো ঠিক আছে। হ্যাঁ হ্যাঁ হ্যাঁ
আচ্ছা ফ্লায়ারে ক্লিক করলে তো ইউটিউবটা ওপেন হওয়ার কথা।
হ্যাঁ 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 হ্যাঁ
হচ্ছে না কেন গো, একটু দাঁড়াও।
আচ্ছা লিঙ্কটা আলাদা করে আমি দিচ্ছি।
তাহলে তুমি আলাদা করে একটু ইনফোতেও দিয়ে দিও।
ওখানে লিংকে ক্লিক করলে খুলছে।
হচ্ছে না, আমার হচ্ছে না।
হ্যাঁ
আচ্ছা অর্কদীপ একটু আমাকে আলাদা করে দিয়ে দিও।
পম্পাদীপ দিয়েছি তোমার।
এবার পেয়েছি।
হুম
গুড আফটারনুন অল। শোনা যাচ্ছে আমার কথা? হ্যালো। আচ্ছা বলছি আমার তো ইউটিউব এক্ষুনি অন করার দরকার নেই, আমাদের কোয়েশ্চেন আনসারের টাইমে খালি লাগবে চ্যাট বক্সটা, তাই তো? একটা নিয়ে করি তাহলে। অত তো দুটোতেই বসে মানে মোটামুটি দুটোই চোখ রাখছো, তাই তো?
কোয়েশ্চেন আনসার কিন্তু শুরু হয়ে যাবে, শোনো সৌমেন্দ্র।
আচ্ছা, হ্যাঁ
কোয়েশ্চেন
বলো।
আনসারটা স্পিকার বলা শুরু করবার সাথে সাথেই অনেক স্টুডেন্টরা লিখতে আরম্ভ করে দেয়। কাজেই তোমাকে যেই
হ্যাঁ,
উনি বলা
সেটা-
স্টার্ট করবেন তখন থেকেই তোমায় চোখ রাখতে হবে।
না, একটা যদি আমরা বলে দিই যে উই উইল টেক আপ অল দ্য কোয়েশ্চেন আনসার্স আফটার দ্য স্পিকার ফিনিশেস, তার মধ্যে হয়তো কেউ কেউ লিখবে, সেটা ঠিক আছে, কিন্তু
হ্যাঁ মানে
আনসারটা ওনাকে
সেটা
রুখতে আমি
ঠিক আছে,
চাইছি।
কিন্তু মানে
হ্যাঁ,
কি
বুঝতে
বলতো
পেরেছি।
মানে সব
লেখাটা
ওনার
স্টার্ট
বলা
করে
হয়ে
দিই।
যাবে তারপর প্রত্যেকে টাইপ করে লিখবে, এটা তো অনেক টাইম কনজিউমিং হয়ে যাবে।
না মানে লিখে রাখো। ঠিক আছে,
হ্যাঁ হ্যাঁ
ঠিক আছে, ঠিক আছে, আমি আছি, অসুবিধা নেই। ঠিক আছে। কিন্তু আনসার গুলো লাস্টেই দেবে মানে স্পিকার
আনসার
আগে বলে
লাস্টে
দিই।
দেবেন।
হ্যাঁ
ওনার কাছে তো প্রশ্নটা তুমি পৌঁছে দেবে, মানে তুমি একটা
হ্যাঁ
খাতা নিয়ে বসে নোট করতে থাকবে ইউটিউবে
হ্যাঁ,
যা যা প্রশ্ন আসছে। এবার
আচ্ছা,
ফাইনালি তার মধ্যে থেকে দেখবে অনেক কোয়েশ্চেন হয়তো রিপিট হচ্ছে, বা অনেক
হ্যাঁ
কোয়েশ্চেন এমন আছে যেটা হয়তো উনি হয়তো এখন বলেননি, আধ ঘন্টা বাদে ওনার টকের মধ্যে তার আনসার উনি অলরেডি দিয়ে দিয়েছেন। তো সেই কোয়েশ্চেনটা আর ওনাকে নতুন করে বলারও দরকার নেই। তো এটা তোমাকে আর কি ওনার টকটাও শুনতে হবে আর ওই কোয়েশ্চেনটাও দেখতে থাকতে হবে। লাস্টে তুমি তোমার পছন্দ মতন হয়তো বেস্ট 5টা বা
হ্যাঁ
10টা প্রশ্ন
আসলে আমি
বেছে
দেখবো
নিয়ে।
টাইমটা, আমি দেখবো টাইমটা
হ্যাঁ হ্যাঁ
কতটা বাকি, কারণ
একদম একদম একদম
আননেসেসারি
হ্যাঁ,
ওটা তো মানে স্ট্রেচ
ওটা
করবো।
আননেসেসারি লেন্দি করে তো লাভ নেই।
Exactly.
একদম।
ঠিক আছে। আরে কৌস্তব দাকে কি লাগছে? কৌস্তব দা,
আমি প্রথম টি শার্ট পরে দেখছি কৌস্তব দাকে।
আমাদের টিসিএস পুরো হ্যান্ডসাম, কথা হবে না। কৌস্তব দা,
হ্যালো,
কথা বলো। প্রিপেড স্কিমে নাকি? দেখো মিউট করে কথা
শোনা
বললে হবে,
যাচ্ছে? হ্যালো,
আনমিউট করো।
অর্কদীপ শোনা যাচ্ছে? হ্যালো,
হ্যাঁ শোনা যাচ্ছে, প্রিন্সিপাল স্যার জয়েন করেছেন। হ্যাঁ
শোনা যাচ্ছে
ও
তো
হ্যাঁ
কথা?
হ্যাঁ, প্রিন্সিপাল স্যার।
হ্যাঁ পরিষ্কার শোনা
হ্যাঁ
যাচ্ছে।
স্যার শোনা যাচ্ছে।
আচ্ছা, ওকে
স্যার কি
ওকে।
কলেজে আছেন মনে হচ্ছে?
আরে কলেজ তো স্যারকে বিকাশ ভবন করতে হবে, স্যারের তো আপনারা তো বোঝেন না, অনেকক্ষণ মিটিং আছে, আরেকটা থেকে বিকাশ ভবন করতে হবে। ঠিক আছে।
পম্পাদি ওই আমাদের স্পিকার কখন জয়েন করবেন?
স্পিকার বলছে 12:30টার মধ্যে জয়েন করবেন।
আচ্ছা ঠিক আছে ঠিক আছে।
উনি জয়েন করলে আমরা স্টার্ট করি।
হ্যাঁ হ্যাঁ
হ্যাঁ
হ্যাঁ হ্যাঁ হ্যাঁ হ্যাঁ
আর সুদর্শন বাবু জয়েন করেছেন?
সুদর্শন স্যার জয়েন করতে পারছিল না, মনে হচ্ছে চেষ্টা করছেন, এক্ষুনি জয়েন করে দেবেন, আমাকে ফোন করেছিলেন।
আইকিউএসি কোঅর্ডিনেটর
হ্যাঁ, অর্ণব স্যার তো করে দিতে।
কর্নেটর করেছেন স্যার।
হ্যাঁ,
অ্যাকচুয়ালি স্টুডেন্টদের কতজন জয়েন করে? স্টুডেন্টদের তো কাউকে দেখতে পাওয়া যাচ্ছে না।
স্যার স্টুডেন্টরা তো ইউটিউবে দেখবে।
হ্যাঁ,
ওরা
স্টুডেন্টদের স্যার এখানে অ্যালাউ করা হবে না এটা।
ওরা ইউটিউবে দেখবে, তাই তো?
হ্যাঁ হ্যাঁ,
ও আচ্ছা আচ্ছা।
স্টুডেন্টদের স্যার এখানে ঢোকালে খুব ডিস্টারবেন্স হয়, ওরা বারবার ধরে ওই জয়েনিং রিকোয়েস্ট পাঠাতে থাকে।
কিন্তু ইউটিউবে কতজন ঢুকলো সেটা আমাদের বোঝা যাবে?
হ্যাঁ হ্যাঁ, ও তো ইউটিউব খুললেই দেখা যাবে কতজন দেখছে।
আচ্ছা, সুদর্শন স্যারের রিকোয়েস্টটা এসে এই অটোমেটিক চলে যাচ্ছে,
হ্যাঁ,
আমি
উনি আমাকে
অ্যাকসেপ্ট
ফোন
করার সুযোগ
করেছিলেন।
পাচ্ছি না, কি
উনি
করবো?
আমাকে ফোন করেছিলেন, ওনার মনে হয়
হ্যাঁ,
ফোনে কোনো প্রবলেম হচ্ছে। আমি বললাম স্যার সুইচ অফ
না
করে একবার
দাঁড়াও,
সুইচ অন
এবার হয়েছে,
করুন।
এবার হয়েছে।
আচ্ছা,
হ্যাঁ স্যার জয়েন করতে পেরেছি।
সুদর্শন স্যার চেষ্টা করছেন অনেকক্ষণ ধরে। হ্যাঁ, আশা করি জয়েন করে গেছে।
হ্যাঁ করে গেছেন জয়েন।
হ্যাঁ, আমি জয়েন করে গেছি। থ্যাংক ইউ।
ওকে স্যার। হ্যাঁ, আমি খুলে রেখেছি, এখনো 8 জন, এইট 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 ওয়াচিং দেখাচ্ছে, ঠিকই লাগছে লাইভ।
আচ্ছা, আমি বৈশাখী ম্যাডামকে একবার ফোন করে নিই, উনি তো অফলাইন দেখাচ্ছে।
হ্যাঁ হ্যাঁ হ্যাঁ,
আমি হোয়াটসঅ্যাপ করলাম কিন্তু উনি অফলাইনে আছেন আর কি, আমি ফোন করে নিচ্ছি।
নাম্বার অফ পার্টিসিপেন্টস তো খুবই কম দেখছি, তো এখনো তো কেউ জয়েন করছে না।
কতজনের জয়েন করার কথা সুদর্শনটা?
তাও তো আমাদের তো ক্যাপাসিটি যা আছে 100-র উপরে, তো আমাদের 100 তো আমাদের
এই গুগল মিটে স্টুডেন্টদের জয়েন করার কথা না, ওরা ইউটিউবে শুনবে।
ও ওরা ইউটিউবে শুনবে, আচ্ছা আচ্ছা আচ্ছা, সরি হ্যাঁ, আচ্ছা আচ্ছা। তাহলে আমাদেরও তো টিচার পার্টিসিপেশনটা একটু হওয়া উচিত। তো ঠিক আছে, দেখা যাক পরে হবে হয়তো।
হ্যাঁ, কথা হয়েছে, উনি জয়েন করছেন এক্ষুনি।
ইউটিউবে এই মুহূর্তে আমাদের সবার ওই স্ক্রিনটা দেখাচ্ছে, মানে সবার
এখনো গ্রিড ভিউটাই দেখা যাচ্ছে, গ্রিড ছাড়া এখনো আসেনি, ওটা একটু দেরিতে আসছে। না, আসেনি এখনো, ওটা দেরিতে আসছে খুব, মানে কথাগুলো অনেক দেরিতে আসছে।
হ্যাঁ, মানে একটা 1 মিনিটের মতো একটা ল্যাগ থাকে।
তুমি ইউটিউবে কেউ জয়েন করেনি বোধহয় এখনো।
না, 31 ওয়াচিং, 34 ওয়াচিং দেখাচ্ছে।
ও আচ্ছা আচ্ছা,
34।
ঠিক আছে ঠিক আছে, হ্যাঁ।
হ্যাঁ, এবার এলো। স্পিকার কি আসছেন পম্পাদি? কথা হলো?
হ্যাঁ, উনি বললেন 2-3 মিনিটে জয়েন করছেন।
Okay, okay, fine.
এই আমি ঘরে আছি। এই মিয়া,
পম্পাদি করবে শুরুর
পম্পাদি
দিকটা।
স্টার্ট করবে, তারপরে
আমি স্টার্ট করে সৌমেন্দ্রকে হ্যান্ড ওভার করে দেবো আর কি। হ্যাঁ,
আমি তো ঘাস মারছি বলো যে টাইপ করে আসলে কি জানো যাই করে মেরা দেখে করতে না আর বসে না তো কিছু টাইম না আমার ঘরে বসে নাই তো ওই নাটা করে নিতে আর এই দিয়ে তারপর আমি যাচ্ছি আপনার
আচ্ছা বৈশাখী ম্যাডাম জয়েন করে গেছে না আমাদের গ্রুপে?
ওকে ওকে,
তাহলে প্রিন্সিপাল স্যার শুরু করি আমরা।
হ্যাঁ চলুন শুরু করুন।
অর্ণব স্যার সুদর্শন স্যারও আছেন তো?
হ্যাঁ আছি।
তাহলে স্যার শুরু করে দিচ্ছি। Good afternoon, everyone. It is my pleasure to open the webinar on intellectual property rights and to welcome you all to this event. First of all, I would like to request our principal, sir, Professor Shital Prasad Chattopadhyay, to say a few words. Sir, please.
হ্যাঁ শুনতে পাওয়া যাচ্ছে? হ্যালো, হ্যাঁ হ্যালো,
Yes, sir.
হ্যাঁ। It is a moment of extreme pleasure for me on behalf of City College to welcome all who are present here to attend this webinar on intellectual property right or become second semester students organized by IQAC of City College. I convey my sincere thanks to all students participants, teachers of Commerce Department, and all members of IQAC, particularly to IQAC coordinator Dr. Arnav Choudhury, and all organizers of the seminar for their effort for this online seminar. On behalf of the institution, I express our heartiest gratitude to our invited speaker, Ms. Boisakhi Ghosal, Advocate, Criminal and Corporate Matters. Thank you, madam, for accepting our invitation, sharing your valuable time, for joining over the webinar to deliver lecture. We are truly delighted with your presence. I wish Speaker Madam, having brilliant educational record and long experience in the field of criminal matter and banking matter, will deliver her lecture in lucid manner. And I am sure all attending this webinar and students will enjoy this important topic of current relevance and will be benefited. I welcome you all again for active participation. I wish a great success of the seminar. Thank you all.
Thank you, sir. Now, I would like to request Professor Arnav Choudhury, Coordinator IQAC City College, to say a few words.
সিটি কলেজের ইন্টারনাল কোয়ালিটি অ্যাসিওরেন্স সেলের তরফ থেকে আমি সকলকে অভিনন্দন জানাচ্ছি এই ওয়েবিনারের নাম আপনারা সবাই জানেন, ইন্টেলেকচুয়াল প্রপার্টি রাইটস, এবং বক্তা হচ্ছেন শ্রীমতী বৈশাখী ঘোষাল। উনি একজন অ্যাডভোকেট অ্যান্ড এক্সপার্ট ইন ক্রিমিনাল অ্যান্ড কর্পোরেট ম্যাটার্স। আশা করি ওনার এই বক্তব্য থেকে আমাদের ছাত্রছাত্রীরা এবং আমার সহকর্মীরা সবাই সমৃদ্ধ হবেন এবং ছাত্রছাত্রীদের আগামী জীবনে ওনার বক্তব্য থেকে পাওয়া জ্ঞান নিয়ে নিশ্চয়ই এগিয়ে যেতে সাহায্য করবে। আমি ধন্যবাদ জানাবো ম্যাডাম বৈশাখী ঘোষালকে, তার মহামূল্যবান সময় থেকে একটুখানি সময় বার করে আমাদের সিটি কলেজে এসছেন এবং আমাদের ছাত্রদের সঙ্গে একটু মেলামেশার সুযোগ আমরা করিয়ে দিতে পেরেছি। আর ধন্যবাদ জানাবো আমাদের প্রিন্সিপাল স্যারকে, যিনি আইকিউএসির জন্য এই সময়টা পার করে দিয়েছেন। আমাদের সমস্ত আইকিউএসির মেম্বারদেরও ধন্যবাদ জানাবো এই ওয়েবিনারের সাফল্য কামনা করে আমি আমার বক্তব্য শেষ করছি। ধন্যবাদ।
Thank you, sir. Now, I would like to request my fellow colleague, Professor Soumendra Laha, Assistant Professor, Department of Commerce, to take over the session charge. Soumendra, please carry on.
Thank you, Pampati. Very good afternoon to all my seniors, Principal Sir, IQC Coordinator, and all the professors present. Very good afternoon to our esteemed guest, Ms. Boishaki Ghoshal, and a very good afternoon to all my students. We are very happy to have Ms. Boishaki Ghoshal today as our resource person. So we expect this upcoming session to be a very informative session for all our students and all of us. So without wasting any time, I would like to invite the head of the department of Sudarshan sir.
Hello. Good afternoon to our honorable principal, distinguished speaker, present teachers, and our IQAC members and our staff students. A very warm welcome to our college webinar. Today, our first area of discussion is IPR, Intellectual Property Rights. I will discuss some few words about IPR before I present. I refer to Boishaki ma'am. For her presentation, I will say something in nutshell about the IPR. Okay. Acha. First, today this chapter which we are trying to discuss, that is intellectual property right, which covers our few syllabus in our big syllabus curriculum. That is, it contains some ideas from you can say economics, IFSA, management, as well as law. All these chapters, students will get some help after after if you continue to learn this IPR. Okay, today, আচ্ছা শোনা যাচ্ছে কি?
হ্যাঁ স্যার
Hello.
হ্যাঁ স্যার শোনা যাচ্ছে।
আচ্ছা, today I will discuss that is IPR, that is three specific words, that is intellectual property and right. Intellectual, in this case, we mean that it is the innovation of ideas, creation of mind, a design and invention, etc., which can be raised to the useful for the product and application. This is the the term intellectual. I mean this. Next, property. Property can be defined in differently. It may be physical property, which consists of land, house, building. Intellectual property consists of some technical terms which are used in IPR, which will be discussed later on. That is patent, trademark, industrial design, trade secret, geographical indication, etc. And another individual property, that is copyright, which are to be discussed in details by our speaker, Viren speaker. From this above property, there may be certain role in the economy which are very much used in day-to-day economy. In the economy, it helps in protecting the ownership and originally of the individual creation. It motivates individual creativity and thus contributes to the economic growth. It provides recognition to the concerned person and authority. It provides also financial benefit and Hello, any problem?
না স্যার আপনি
না না
বলুন।
স্যার শোনা যাচ্ছে, আপনি বলুন।
Acha. It provides financial benefit and also property have to be created. It provides financial incentive to the creation of monopoly. It also improves the financial status and individual as well as the economic development of the country. Moreover, it enhances the performance of the level of institution. Acha. This IPR also create a competition among the researchers and also institution for the quality of research. These are the role played by the IPR in the present economy. Lastly, I will say something about rights. Rights means the right is an indicator, is the derived economic benefits from the intellectual property, the thought, the right. This is called right. The IPR are legal rights and protect creation, invention resulting from intellectual activity in the industrial, scientific, literary, and artistic field. This right should be well protected from the stolen in the invention which the law was passed in the Paris Convention. Okay, this is all about I told about the in nutshell, in a very nutshell. Now I would like to invite our today's distinguished speaker, Mrs. Hoishaki Ghoshal, for her presentation. Please.
Ma'am, can you hear us, ma'am? Hello. Hello. Hoishaki ma'am, madam, can you hear us? Hello. Yes, she's there.
Hello?
Yes.
Is it clear?
Yes, ma'am. Yes,
Audible
ma'am.
is clear? Yeah,
Yes,
yeah,
ma'am.
yeah.
Ma'am, so you can
Thank
start.
you.
Ma'am,
Yeah.
just one thing I would like to tell all the students. Students, just keep one thing in mind. When madam is speaking, if you want to ask any question, you can write it in your chat box, in the YouTube chat box. Okay, we'll take up the question at the end of the session once the speaker finishes. Then we take up the question answers. Okay. Okay. Thank you, all students. Thank you, ma'am. You can continue. Thank you.
Thank you. Thank you. Yeah. Good afternoon, everyone. Welcome you all. I am Boishaki Ghoshal. Yeah. Today I am going to discuss. Is it clear, na? Audible is clear?
Absolutely, ma'am. Absolutely.
Yeah. Yeah. Today I am going to discuss the topic how far the IPR is relevant at modern society. So first of all, I will give you the brief idea about IPR or intellectual property rights. What is IPR? Then I will discuss in a nutshell the emergence of IPR in international scenario to the national scenario. Thereafter, I will discuss in brief the different fields of IPR, which is very much relevant in our daily life or as well as modern society. And I trying to make you understand the necessity of IPR at modern society. This will be a brief discussion. Please save the questions for the end of the talk. Okay. Yeah. Now I will discuss that what is the IPR? The IPR is intellectual property rights. The intellectual means the things related with human intelligence, creativity, and innovation. And the property everybody know that it is a two types of property which is possessed by, owned by someone or somebody. And the property in a broad sense, we can distinguish it as a tangible and intangible. Tangible means that we can touch the property. That is our movable, immovable properties. And the intangible property means which we cannot touch. But these are also properties. That is one of them is the creativity of human being, which is under the IPR. And the right is the one's interest is protected by law. So intellectual property rights is related with the creative genus of a human being, which is totally related with the creative genus. And why property intellectual? This property, because it is exploited, can earn wealth. That's why it is called as a property. And so why the legal protection is necessary for intellectual property? Because every human creativity which promote economic, social, scientific, and cultural development of society must be encouraged. Otherwise, our society will become a stagnant. And the creator of this creativity must be suitably rewarded by certifying legal protection to his intellectual creation. Otherwise, we can't promote or encourage for this creativity. So, this is the intellectual, what is the meaning of intellectual property rights? Now we will focus on the development or emergence of intellectual property right in the international field as well as in our national scenario. So, industrial revolution in the 19th century increases the invention. Similarly, creative genus of scientists, artists, literary writers resulted into need for a legal protection of intellectual creativity.
So in this effort, the first multilateral effort was made through Paris Convention for protection of industrial property held on long back 20th March in the year of 1883. That is the starting of the emergence of intellectual property rights. Thereafter, in several conventions and the Berne Convention of the Switzerland, which is these two conventions are called as the Magna Carta of IPRs. And thereafter, the IPR has made a long journey. Since then, IPR regime has made with the establishment of WIPO, that is World Intellectual Property Organization, and the agreement of TRIPS, Trade Related Intellectual Property Rights, is the jurisprudence has firmly established at international as well as national level. The foundation jurisprudence of IPR has built up brick by brick through various international conventions and agreements. The beginning from the Paris Convention and end in the WTO and TRIPS agreement. And before go through the different wings of the IPR, we have to first discuss what is the WIPO, that is World Intellectual Property Organization. This Intellectual Property Organization is a landmark event in the history of promotion and protection of IPR at global level. At Stockholm Convention in 14th July 1967, the WIPO has been established, and WIPO is designated as specialized body of the United Nations and also acts as a complementary body of WTO, that is World Trade Organization, is the promotion and protection of IPR is concerned. So WIPO is one of the strongest part to promote and protect the intellectual property right, as well as our national scenario and also in the global scenario. And the headquarters of WIPO is established in Geneva. And thereafter, another important organization is World Trade Organization, which has been established on the 1st January 1995 and came into force in the 1st January 1996, which is replacing the GATT, which known to everybody, the General Agreement of Tariffs and Trade, which after replacement of GATT, the WTO has come into force in the year of 1996, 1st January. The creation of WTO is also a landmark in the history of multilateral trading system after considering the structural changes in the world economy. Another landmark thing is TRIPS, which is nothing but a binding global charter of IPRs, which is a trade-related intellectual property agreement. That is, in short, not called TRIPS. The TRIPS agreement for the first time creates a multilateral framework for enforcement of intellectual property rights, which were so far left to the nation states to carry out and their discretion under national law. It is a mandatory agreement, that is TRIPS is the mandatory agreement attached to WTO, that is World Trade Organization. And every member of World Trade Organization is required to observe the provision of TRIPS and provide a minimum level of IPR in their national laws. Failure to comply with the minimum prescribed requirement will face penal provision of WTO. So now we can understand why TRIPS is called as a binding global charter. Every country of the world who is a member of WTO must follow the guidelines of TRIPS. And now, as per that agreement, there are the several wings of in the IPR. Now we will categorize that the which has been covered by the TRIPS agreement under the IPR. So the first is copyright related right is covered under the IPR. Another one is trademark is also comes under the purview of IPR. Another one is geographical indications. Next, industrial design. Next, patent law. Another one is layout designs of integrated circuits. And protection of undisclosed information is also comes under the TRIPS agreement as per IPR. And control of anti-competitive practices in contractual licenses. These are the categories which comes under the purview of IPR. These are the, till now I have discussed the international scenario of IPR in very nutshell, and also the emergence of WIPO, WTO, and TRIPS. But now we are going to our next topic in very nutshell, the national regime of IPR. What is the scenario of IPR in our country? Now, we will give a brief look at various legislative measures strengthen IPR system and also to be adopted in India to redeem its international obligations arising out of various conventions and international agreements to which India has been an effective member. And you will be surprised to know, as India was a founding member of WTO, and India has taken timely steps in amending and enacting various statutes relating to patent, copyright, trademark, geographical indications, plant varieties and farmers' right, and biodiversity. So the India, which is under the Indian law, there are several laws which comes under the purview of intellectual property rights. There are, now I will just mention all the laws which comes under the IPR in our national vision. The first act is, the oldest act is Copyright Act, which has been enacted in the year of 1957 and later amended day by day. A big amendment took place in the year of 1999. Second one is the Patent Act of 1970, and also the Patent Act has been amended in 1999, 2002, 2005, and there are also amendments of minor amendments. These are all major amendments I am mentioning, and thereafter the minor amendments is going on day by day. Third one is the Trademarks Act of 1999, which repealed the Trademarks and Merchandise Act of 1958. And now the Trademarks Act of 1999 come into force. Another fourth one is the Geographical Indication of Goods Registration and Protection Act of 1999. Next one, fifth one is the Designs Act of 2000. Sixth one is the Semiconductor Integrated Circuits Layout Design Act of 2000. The Protection of Plant Varieties and Farmers' Right Act of 2001. And the last but not the least, the Biological Diversity Act of 2002. So all these are the acts comes under the purview of intellectual property rights. The year of the enactment of the act will clearly says that all acts are very, very newly amended or enacted acts. So IPR is emerging day after day. Regularly, the importance of IPR, we are realizing the importance of IPR. So now I'm in a very nutshell will discuss 2 or 3 main wings, which is the main pillar or basic pillar of IPR, which we are regularly going through all these laws, not only laws, the things. Now I will first discuss the copyright and related rights, which is the one of the strongest part of the intellectual property right. Now, what is copyright? Copyright is the anybody can get the copyright, the literally work. What means dissertation, that is the research work of anybody in a question papers. If anybody or any college or any institution made a question paper, and that institution and college can get the copyright over that question paper, nobody can infringe that question paper or anything. Then encyclopedia, making of dictionaries, translate of anybody's writing or anything, different computer programs or tables, complications including computer database. One can get copyright in all these items, and in artistic works also, it is in painting, in photograph. Say, there are we are very much, it is related with the copyright in painting and also the photographs. Anybody can take an exclusive photograph, he can claim copyright over that photograph. That photograph cannot be infringed, or the painting cannot be duplicated. So we can get copyright over painting, photograph, and also the musical work. A musical work in songs. And in a songs, it is a one peculiar thing. The words of the song create a copyright in the author. If anybody wants anybody can write a song and he can claim copyright over the song, the words of the song. But the music of the song is the copyright of the composer. It's a so a song, and anybody can give a music to the song. The composer can claim the copyright, but the song itself has no copyright, because the author of the words can get the copyright, or composer can get the copyright of the music. But if the song written and composed by the same man, then he can get the copyright of the song. Otherwise, the song cannot, nobody can get the copyright of any song. And also, under the musical work, anybody can get a copyright in a cinematograph film, any sound recording. And another thing has been amended before 1999 or that type. A computer is not so many very much relevant or related with our day-to-day life. But thereafter, in the amendment of 1999, any computer software and programs are also under the purview of Copyright Act. And work of architecture means any layout of a garden. Suppose a layout of a garden. Layout means how many steps that garden contains, the walls, the decoration of the walls, the ponds, the fountains. That is the architecture work is also under the purview of copyright. So just we have gone through a small wing of IPR, that is a copyright. Now we can realize that how much this is relevant. Everything every day we are hearing music. Every day we are seeing a paintings, exclusive photographs. But all these can be protected by the creator through Copyright Act, and which is very much relevant under the intellectual property rights. Now, the next part of the copyright is a patent law. This is a patent law is enacted in the year of 1970, and thereafter, due to the emergence of the technicalities and the everything, it has been amended day by day. And patent is granted for inventions which have industrial and commercial value. Any person whose invention has novelty involving inventive steps, which is non-obvious, and is of industrial application, can be granted a monopoly right for a certain term to commercially exploit its invention and earn profit out of its invention. So, patent is basically related with the creativity of any normal, which is novelty work, inventive steps, any. Now, patent become the major subject of controversy between developed and developing countries. Everybody know the which is a wing of partly science and biotechnology. Nowadays, a biotechnology patent is very much relevant with the biological research. We have everybody heard that a cloned ship, a dolly, long back, which is a development of the biological patent, that cloning, that has been also protected by the patent. And Patent Amendment Act has been revised in 2002, which gives the uniform term of a patent of 20 years from the date of application. So anybody's creation which has been patented, which can be protected for the 20 years after 2002 Amendment Act. And after the Amendment Act of 2005, the patent can be issued in the areas of drugs, foods, chemicals, like this. Various sections of the Indian economy, including biotech and software, also introduced in the year of 2005. Thereafter, after this inclusion, that is biotech and software technology under the patent, the patent is one of the most important wing of IPR nowadays. That is provision for enabling the grant of compulsory license for export of patented medicine to countries which have insufficient or no manufacturing capacity to meet a public health emergencies such as HIV, AIDS, as per Doha Declaration of Public Health, is also included in the year of 2005. So, patent is a legal grant of monopoly right for some fixed term to the creator of new and useful invention in return of his disclosing the invention. Now, patent is granted by each country in accordance with its patent law. Although, with the coming into force of Patent Cooperation Treaty, that is PCT, a single application can be filed in any of the member countries for claiming priority invention has to obtain patent in each country separately. But till date, there is nothing like a global patent. And one thing I have to be mentioned that the inventions relating to atomic energy are not patentable. In the invention of atomic energy in a patent is not allowed. And one of the interesting things is that patent is a transferable property. The owner of a patent, that is patentee, can transfer partially or fully his patent to another person, either for consideration or without consideration, by the way of there is an assignment, by the way of transmission, by the way of license. So now we can realize why these intellectual things, why called the property? Because we can, in consideration of that, we can earn wealth also. And another, the interesting part, and which is very much relevant to us. Obviously, the copyright and patent is also relevant. And another strong wing of the IPR is the trademarks and service marks, which is guided by the Trademarks Act, which I've already discussed earlier. That is a newly Act of 1999. So, what is the trademark? Everybody is very much familiar with this trademark because everybody look about the trademark and anything every time we're going to purchase or everything we are going to buy. But trademark is a symbol through which goods are sold in the market. It is a symbol which may denote and distinguish goods of competing traders. These trademarks maybe consist a single letter, maybe numerals. Later on I will give you an example, then it will be clear to you. It may be a logo, it may be a design, or it may be the word, pictorial devices, or combination of words and devices. A trademark can be anything. So, a trade, there is you will get another term, service mark, which is nothing but a trademark, but the using of these trademarks is in a specific area, that is for service area, then it is called a service mark. That is the same trademark or like that thing when used in a banking, when used by the telecommunication, when used by the airlines or tourism. For these service providers, then these trademarks are called as a service marks. But there is no big difference between trademarks and service marks. That trademarks are when used for the service purposes, then these trademarks are termed as a service marks. So, trade and commerce now is the lifeline of economy of any country. Everybody knows it. Without trade and commerce, our life will become a stagnant, and everybody realized for the past 2 years how pandemic has stagnated our life and this seal our economic and lifeline also. Because due to this, every trade and commerce has been seized. That so trade and commerce is the lifeline of our economy, really the lifeline. In an area of competitive economics, the goods which are traded by their names which may indicate their quality and identity distinct from others. Obviously, trademark is by far the most commonly used intellectual property rights today. The importance of trademarks was also first recognized at the global level through Madrid Agreement in the year of 1891, long back. And in India, I have already told you, the Trademark Act has totally newly enacted in the year of 1999. And what is the object of this Trademarks Act by law? The first object is to provide legal protection of trademarks for goods and services to prevent fraudulent use of marks. And the unique feature of trademark is, which distinguished from other categories of IPR, that is the copyright, patent, and design, is that trademark are given legal protection not for a fixed term. That I have already discussed. The patent we can give up. Anybody can get a patent on his work or anything for the term of 20 years. But in the Trademark Act, we can give a legal protection for an indefinite term, but subjected to certain legal conditions and renewal capacity fulfilled. But it can be granted for indefinite period. And trademark includes within itself also a trade name under which any articles can sold, which is a very common to us. Suppose a Kirloskar, Bajaj, Godrej. These are all trade name and also have their particular trademarks. If we see a Godrej, any product, now with the name of the trade name, there we also have a symbol or sign of the Godrej. This is a sign of a Godrej. Everybody can mark it. And trademark is generally transmitted in connection with the goodwill of a business. Everybody know it. Therefore, law does not recognize the transfer of only the trademark separate from the goodwill of the business. Because suppose the Godrej wants to transfer his trademark, except the goodwill. So it is not possible because the trademark is always related with the trade name also. Now I will just give a 2-3 examples of a trademark. Then suppose tortoise. If we see the spelling tortoise, TORTOISE. So just within a second, it is come to our mind that it is a brand of mosquito coil. Everybody knows that green color coil is a tortoise coil, mosquito coil. So another letters of LG, big LG, IBM. LG, if we know that, after seeing the letter LG, we will realize that it is electronic goods, or either it is a fridge, or either it is a AC of LG. So sometimes it may be like a label or ticket that is Wrangler. Just when this tag comes our mind, then you will say, this is a tag of jeans. Zodiac. This is the tag of shorts or ties. But these are all trademarks. And another one number, I think that is not available now, but a few years later, that is when it comes into 555, 3 numbers. So obviously it is a cigarettes. Then 555 is a trademark of that cigarettes, a good quality cigarette. And sometimes trademark can be a shape of the goods, also be a trademark. Different shops have a different, that is Dove. If we just if we close our eyes and feel the shape of the soap Dove, we can feel it. This is a Dove. Shape of a different bottle, we can feel it. These are the shapes can also be a trademark, which is nothing but a IPR, under the IPR. even sometimes a title of a book is also a trademark. Just India Today. India Today is not a book, but it's a brand name. Femina is also a brand name. And these names are also the trademarks of a book. Once we think the India Today, those who can go through the India Today magazine or those who can go through the Femina magazine, immediately it's come to the mind that these things are like in this book. So sometimes a title is also a trademark. So service mark. Certification of trademark is a mark capable of the distinguishing of goods or service in connection with which it is used in the course of a trade, which are certified by the proprietor of the mark in respect of origin, material, mode, and manufacture. Just if I give you the example, then you will realize sometimes service mark is given for the performance of the service, quality, accuracy. That is, suppose everybody is accustomed to the term hallmark. When hallmark come into our mind, obviously it is related with the gold jewelry. So egg mark for food items, silk mark for clothes. So these are also the trademarks, but this hallmark is not like a just now I have discussed that is a particular brand or particular logo, but these hallmarks means the mark which is certification of the trademark in the name of a person who carries trade in goods of the kind, certified for a trade for the provision of services of the kind certified. Means the service, those who are providing, those who are possessing the hallmark, then they are giving the service of the material accuracy of the service. These marks are given for the service, that is the self mark. When any merchant giving us or providing a self mark, then he is assuring for his service of the accuracy of the cloth or manufacture of the cloth, and the service is providing, that is, it is the 10% silk providing to us. So this service mark is the giving the service of the origin, material, mode of manufacture of goods and performance of the quality of the services and accuracy. And another thing, also in computer, the domain name, that is in any site when http a colon, a slash, then this domain name is also under the purview of the trademarks and as well as the IPR. Another thing, another important part of the IPR, in our everything that I'm discussing in the Copyright Act, the patent law, and just the trademark, all are in the Indian scenario. I'm discussing about which is relevant, very much relevant to the Indian scenario, because the several acts are not very much relevant with the Indian scenario. It is not too much applicable, have too much applicability, but the which are applicable in India. Another one is geographical indication, which is another part of the IPR. The geographical indication is that an indication which identifies goods, which may be natural goods, may be agriculturally cultivated goods, or maybe manufactured goods is originating in the territory of any country or any region or in locality. The territory are called as a geographical indication. And this indication, geography, we everybody know this come under from the term the geography, and indications already explained the indications. Indications denote the any quality, maybe a taste, maybe the aroma of the product, maybe the reputation, or other characteristics such as goods essentially attribute to its geographical origin. And like just perfume of a Paris perfume, Scotch whiskey, basmati rice, Darjeeling tea, Swiss chocolate, Kashmiri apple, this Nagpur orange. These are all indicates the geographical indications. And Bikaner bhujia, silk of a Benares silk, Russian vodka. These are have the special importance on account of their association with indication source. It is once we hear the Darjeeling tea, oh, we realize it is famous for its aroma. The Kashmiri apple, just these are called geographical indication, which is also comes under the purview of the IPR, intellectual property rights. And for the geographical indication, the registration is the mandatory, and it can be given for the 10 years, then it can be renewed. And one is everybody can remember this a few years back, the origin of Rasagulla, whether it is in Orissa or Bengal, there is a great tussle with the geographical indication of the Rasagulla. Then after various tussle, Kolkata get the geographical indications mark of the Rasagulla. Everybody knows it, which is also the tussle is under the IPR. Now, another thing is another part which is important, a little bit important, industrial design. Another part of the IPR. The industrial design means obviously related with the industry, only means the features of shape, configuration, any pattern or any ornament or composition of lines or color applied to any article, whether it is a two-dimensional design or three-dimensional design or in the both form for the industrial process. Whether it is a manual or whether it is a mechanical or a chemical, which we can be judged by our eyes. These industrial designs are also any sort of industrial design which is unique, or if one wants to protect it, then he can protect under the Designs Act of 2000. So these 5 wings, which I have discussed in a very nutshell within this short span of time, that is a copyright and related right, patent law. Another one is trademark and service marks. 4th is geographical indication, and this industrial design. These 5 wings have immense impact on our modern society and our day-to-day life scenario in respect to intellectual property rights. And now there are or two or three things, that is the Agriculture and Farmers' Rights, Biodiversity Act. But these acts till today have, like Trademark Act or like Copyright Act, these are very negligible application till date. So now I have trying to explain total IPR and its being in very nutshell. And now I will conclude that now at the global level, certain efforts are being made to address the concerns of the third world countries, including India, in connection with issues like protection of public health, traditional knowledge, and prevention of biopiracy. These are now, there are efforts is going in a global level to make awareness regarding a new field of IPR. The Intellectual Property Rights Commission has been established by the government of Britain, is doing a tremendous work in this area, particularly in protection of public health, in the traditional knowledge, preventing of biopiracy, and also come up with certain important suggestions to protect the interest of the people of the developing as well as underdeveloped countries. Similarly, the World Intellectual Property Organization, that is WIPO, has also initiated steps to protect and promote traditional knowledge and genetic resources by constituting an intergovernmental committee for the purpose of studying and suggesting numerous in the above discussion. Because if the intergovernmental body are not formed, then in the global scenario, it is very difficult to communicate or to achieve these types of patent, copyright, and everything globally. But the debate on the issue of identifying the benefit claimers, the shareholders, and the stakeholders of traditional knowledge and geographical indication has already started become the constitute public property. But therefore, a conflict already arises as the IPRs being privatized and recognized by TRIPS agreement, and some of them being recognized as a public property. So it's very difficult once a geographical indication has been awarded, then it is whether it is a public right or whether it is a private right, there is a controversy, big controversy. So now we will hope that in the coming years we will find a solution to solve these problems, and we will hope that the field of IPR will be an inevitable part of our life. Already it is an inevitable part of our life, whether we understand IPR or not. Everybody is going for a trademark, copyright, everything we are concerned about it. And also in future, we will have a great field of IPR which will have an impact on our society and will protect the interest of our person as well as our society also. So that is all I wanted to say about. Thank you for listening. And now the session is open for discussion.
Okay. Thank you so much, ma'am, for this excellent deliberations. I mean, for such an insightful lecture and for such a lucid kind of explanations. So I'm pretty confident that all of our students must have enjoyed thoroughly. Not only students, the professors as well. Thank you for that. Now, students, I just would like to tell you two things. First of all, I know you have typed a number of questions which I will be putting forward in front of the speaker. But before I do that, please check out your inboxes. The link for your feedback forms has been already given. So please fill up the feedback link that is given or provided in the YouTube inboxes so that you can get your certificate. If you're not filled your feedback, it will be difficult to get the certificate. So I again request all the students, please fill up the feedback form through the link as provided in the inbox. Okay. So, ma'am, I take up few questions that has been asked by our students. Okay. So the first question which has been asked by Samajit is that, I hope you can hear me, ma'am, right?
Yeah,
So,
properly.
okay. Is does royalty comes under IPR? If yes, how it works? Okay. If you can just shortly, in a very brief way, if you can, ma'am, tell us. Royalty, he has asked whether it is under IPR. If it yes, so how it works?
Royalty for what?
Yes, just mention the term royalty, not any specific royalty. If you can just brief all in a general way, ma'am. I think, yes.
Actually, in IPR, you have to specify the word royalty, because royalty is
Okay.
also another covers so many purviews.
Right.
Suppose it may be under copyright, maybe under patent, maybe under trademark. So it should be obviously a part of the royalties covers under IPR, but it should be specific what kind of royalty is it, because otherwise the particular kind is not mentioned. Obviously comes under the purview of IPR, but the type it should be mentioned.
Okay. So
Right.
Samajit, okay. So thank you for that answer, ma'am. Thus it should have been asked specifically. So I think the student must have got his answer. The next question, which is put forward by Uzma Arib, is what is the minimum level of IPR? So what
This
is the
question
minimum level of IPR? I think this
yeah,
question little sounds incomplete. Okay.
Yeah,
Okay.
minimum level of IPR, I can't get it
Exactly, ma'am.
properly.
Sure,
Again, it
sure,
is
sure.
like a royalty question also.
Yes, ma'am. Yes, ma'am. Okay.
So they
Now I would, ma'am, I have one or two questions, but I would also request other students and other professors, anybody, if you want any question or any clarification from ma'am, please write in either of the inboxes in the Google Meet or inboxes of YouTube as you think fit. Any, ma'am. In the meantime, I would like to ask one question with your permission. I have one
definitely.
question in mind that I have a question regarding the infringement of this law. Like, if there is an infringement of any of the IPA rules or any
Yeah.
sections, now
Yeah,
is that infringement considered as a criminal or a civil, or both?
No, both as the criminal, or for every that is for copyright act, there is a, if there is an infringement, you can get the civil as well as criminal remedy. For the patent, there is the different civil and criminal remedy. For the trademarks, for each and every act, there you will get both civil as well as criminal remedy. If the when it is an infringement, if it is under the suppose cheating, suppose a trademark when is cheating, then you will
Right,
get the criminal remedy, or otherwise then it is a civil remedy. Or suppose in a trademark or service mark, if it is a registered, then it will, if you will get the damage, that is civil remedy. Or if it is an unregistered trademark, then it will get a remedy like a passing off. I have not discussed all this because
no,
it
no,
will be a very litigation,
absolutely,
yeah, because
absolutely, ma'am.
in
It's a huge
for
area.
each and every area you will get both civil and criminal remedies, but the way of infringement you have to explain on the basis of the way of infringement, how it has been infringed,
Okay.
whether it is a intentionally infringed and with a criminal motive, then you will get the criminal remedy under the 420, or there are several acts. Or otherwise, major portion you will get the civil remedy, that is monetary compensation or damage, which is monetary compensation. Most of the infringement get the civil remedies, that is damage. The most of the companies need the monetary compensation. for our name and fame and everything. So most of the cases, most of the infringement get the monetary damages, that is civil damage, civil nature. But you can get both criminal and civil remedies.
And one small one just another question, and then I will think Kostobda will be asking one question. What I feel. Kostobda, 1 minute. Just I finish off. Ma'am, you talked about global patents. Okay. So in case of any infringement or any dispute arising out of any global patents, in which kind of courts are these kind of cases sorted out? I mean, in international courts or any specific kind of tribunals? Or yes.
Actually, one I have mentioned that actually there is no global patent it given. There is no global patent is there. Your patent is given by your country law. So in case of whether it is a global, whatever you have to initiate from the very beginning, that is your local court or local body. Then you can go, that is go up to international court and everything. If it is a related, and also it comes under the purview of the TRIPS agreement. Everything is written over there.
Thank you so much, ma'am. Yes, Kostobda, I think you have a question. Please go ahead.
Yes, I'm Kostobda. Can you hear me out? I am Kostobda from the Department of History, and I have been listening to your very insightful and incisive lecture, and I have been following up. Yes, and I've been following the points very avidly. Now the thing is that during the pandemic in the last 2 years, we have noticed one particular trend with regard to intellectual property rights, and that is the European Union members simply refuse to divulge or rather share their what should I say intellectual property with regard to the manufacture of medicines with India, because India is already the what should I say the manufacturing of generic drugs, and it is virtually the pharmaceutical factory of the world. And this has also been the refrain of many African countries, that the developed Western countries are practically refusing refusing to give access to the manufacturing process of the different generic drugs that are essential or fundamental for the cure of COVID. So what do you make of this? Don't you think that the West has double standards when it comes to the developing world?
Actually, this is a different issue. Actually, we are, if we are researching on manufacturing on the drugs or which is protected under the IPR, that by the patent law, which has been drugs for the innovative work that and for our that Covaxin or Covishield, we have the patented, that is for Hyderabad Institute, that is Indian drug has been got patent, which is the AstraZeneca in Britain. They have got the patent of AstraZeneca, and for our India, we have got the patent of that Covishield or Covaxin. So IPR is only concerned to give the patent which is innovative to anybody or any institution. Or IPR is not related with any country is not giving us access, or that is a completely different issue. That is, our IPR is only related with the giving us the patent in drugs or biotechnology, or we will get the patent and nobody can infringe our research work, or nobody can use that composition by hampering our research.
Yes, I would like.
This is the protection of IPR.
Yes, I would like to make a small conjecture at this point. It is this, that the United States of America had been very active with regard to the patenting of Indian biodiversity products like neem, turmeric, etc. And this case was actively pursued by environmental activist Vandana Shiva. And it was by her initiative that the patenting of neem and turmeric was prevented. So if the developed world pursues its own interest on the one hand, so why shouldn't the developing countries be free to, well, at least ask for permission to patent the drugs for saving the lives of the people who are afflicted with numerous diseases?
Actually, those who will apply for the patent, that is a particular person, a particular company, will have to ask patent for their research or for their drugs which have the unique composition and which will be benefit for public health. Actually, in the conclusion, I have already told that for the conference has been held in Britain, and they have for the development of public health and hygiene in that issue, the work is going on for the developed and underdeveloped countries for the public health and issues to get, because the one thing is that we are actually not very much aware of these laws, that is IPR, how to obtain patent, how it can be protected. That for awareness, basic thing is awareness. Our country is maybe called developing country, maybe called underdeveloped country, because the population explosion, we are, most of the people are doesn't aware about this IPR or this patent or everything. So unless and until this awareness is made, so in first world country, everybody is doing a unique work. They obtain the patent, obtain the copyright. But in our country, like India, nobody is bothered about the for his own work or own research. Nobody is claiming for a patent or copyright. So due to lack of the awareness, so it is a we are the people who can aware and who can develop or progress with these things.
And these are
Otherwise, it is not possible.
right.
I think.
Actually these are actually the demographic and legal loopholes that the pharmaceutical companies seek to exploit. Because the more ignorant we are, the better position they are in to market their products and to get the best out of us.
Okay, Kostabda, thanks a lot for such a lovely question, and thank you also, absolutely, ma'am, for answering so well. I mean, I think we have got a very good insights as far as IPR is concerned. I think I will, before handing over to SM, sir, just one last question from the student's point of view. Ma'am, if any student wants to pursue a dedicated career on IPR, okay, and what kind of course he or she should join, because it's upcoming. I mean, as far as IPR is concerned, what I feel from your lecture that it's very popular and becoming more and more popular day by day, as far as our knowledge
It's a
economy
huge
is
field.
concerned. So, ma'am, yes, ma'am. If a student wants to pursue, how he or she should approach before, I mean, after graduation, because mostly we are having, I mean, not mostly, all of them are graduation
Graduating.
students. Yes. So,
Actually,
what they
yeah, if anybody work with IPR, it is a completely legal field. He has to possess a legal degree first. Then he have to done a specialization like any other field. In IPR, there is a specialization. He can do specialization in masters in patent. He can specialize in Copyright Act, or he can specialize in biotechnology field. There is a numerous field in specialization, but basic thing is he had to possess a legal field. Otherwise, he have no legal degree, so it is not possible for him to protect or anything. He must possess a legal degree.
Okay. Thank you so much, ma'am. I would like to hand over to our Professor Siddhartha Mojumdar, sir. He is a very senior professor of Department of Economics. Sir, can you hear me? Hello.
Yes, I can hear you. I can hear you.
Good afternoon, sir. Sir, all over to you, sir. Thank you, sir.
Well, unfortunately, I'm not in college. Others are also have also logged in from perhaps their homes or perhaps from the college. But unfortunately, I am in office and quite busy also. So I couldn't log in at the right time, but I logged in during the concluding part of your lecture, madam. And it was wonderful, very informative, very lucid. Am I audible?
Yeah,
Absolutely, sir. Absolutely, sir.
Absolutely.
Very informative and very lucid. And I listened to the question answer session also. You answered all the questions, handled all the questions with elan. It was a wonderful lecture, and my mind went back to the early 90s and in the early 2000s. For 10 years, about a decade, India was agog. The intellectual community, rather, not only the intellectual community, it was a common farmer, it was a common man going to the medicine shop, They had all one question in mind. Will it cost more? Will it affect my livelihood? Because there was so much publicity about IPR. I do not think any law as such, an international law, can evoke so much of interest and concern among the people. Of course, some of the concern was politically motivated, but there was ground for concern also, because we were concerned about the medicine prices. The farmers were concerned about the sui generis system that was to come in, and what impact would it have on their livelihood. And everybody was concerned. People were blaming the pharma companies, the big pharma companies, of trying to gain unlawful profit through this backdoor, through this IPR regime after the Marrakesh Agreement. And I also fondly recall one morning in late March or early 2000, early April in 2005. It was perhaps the day of enactment of the Patent Act amendment being tabled in the Parliament. No?
Yeah.
Madam, it was April 2005 or late March 2005?
April or March.
April 2005, yes, when the Indian Patent Act of 1970
Amended.
was
Immensely amended.
yes, yes. And on that very day, Department of Economics and Department of Commerce, hosted a seminar on the very topic on intellectual property rights. Of course, those days it was a seminar, not a webinar, as in these days in the post-COVID scenario. And it was a stimulating discussion also, just as it was today. And I also fondly recall that day. Big thanks to the IQAC team, because they are doing a wonderful job to sensitize the students with such lively lectures, informative lectures, thinking out of the box, because they are organizing a seminar or webinar on intellectual property rights. It's a nice thing, because these things we do not usually study at college. Somendra asked a question about what career can they pursue, and you answered, of course. Yes, it's a very interesting thing and offers perhaps a lucrative career, but you have to be in the legal profession also. I had one or two questions in mind, but I should not ask now, just because Madam is a legal professional. And in those days, Madam, we were concerned about the rising pharma prices. We were concerned about, unless patent acts were modified, amended, aligned to the WTO regime, we would miss out on foreign direct investment. I do not know whether any meaningful study has been conducted on that or not. I do not really know about it. But Madam, being in the legal profession, are you aware of any substantial or significant or out of ordinary rise in pharma prices that can be attributed to enactment of this new intellectual property right regime?
Actually, I have already
Madam?
discussed. Yeah, I have already discussed. There is a Farmers Protection Act is already there under the IPR, but I have already told you that it is the Protection of Plant Varieties as Farmers' Rights Act already enacted in the year of 2001. Hello?
Yes, ma'am. Yes, ma'am.
Yeah, already enacted in the year of 2001. But due to the lack of awareness, so there is no proper implementation of the act. Act is there. Act is amending. Those who are sitting in the parliament, they are amending the act as per need. But we are the people who can implement the act. So it should be reached to the farmers. They should aware about the act that I have already told that in the country like India, most of the people are under the poverty level, they are uneducated. So if they are uneducated, there are so many acts, but how can they aware of the act? We are the people who can get them aware that they have such type of protection. We are the people who can make them to implement the act. Because most of the farmers are uneducated, they even don't know what is law, how they are protected, what are the acts. And those who are making the acts, they are in the parliament. Act is every day they are implementing the act, enacting the act, amending the act. But that is not the thing. The main point of law is not making the act or law, but the implementation. So we are the people who can implement the act, make the farmers aware and everything. But these are the Protection of Plant Varieties Farmers Act, the Biological Diversity Acts had no proper and big implementation till today. Am I clear?
Yes, ma'am. Absolutely. Thank you. Thank you so much, ma'am, for this wonderful explanation with regard to the answer. I think sir is somehow got disconnected because
I also
yeah.
think so.
Yes. Acha, just ma'am, just a second.
I got disconnected
He's there.
and
Yes.
I didn't realize it. And I
Yeah,
went on talking.
one second, I am repeating, sir. The question you have asked, that is, there is already a law under the IPR, the Protection of Plant Varieties and Farmers' Right Act, which has been enacted in the year of 2001. But the main thing is that in our country, most of the farmers and the people under the poverty line and uneducated. So they even don't know what is the act or what is like that, how to implement it or how to get protection regarding the law. So every day these type of acts is enacted and amending, but it is we are the people who can make the farmers or these people aware about the act and how to implement it and get protected under this act. Am I clear? There is a
Yes,
act
yes, yes.
already act under the IPR, but it has no use. I already explained in my lecture that there are so many acts under IPR, but these are no implementation till today. That is the Biological Diversity Act 2002, which is a newly act, but it has no proper implementation till date because nobody is aware of the act. We are the people, we all can make them aware because the farmers are, most of them are under poverty line, they're uneducated, so they are running for their bread and butter. How can they know what is law? How can get the protection from law? How they can implement? This is the big problem of our country. We have every kind of law, but there is no implementation of that kind of laws. That is the problem. Because most of the people doesn't know what is law, how to implement it, how to get protection about it.
Thank you, madam. Thank you. Thank you for the clarification. Actually, there is a slight connectivity problem where I am sitting. Before continuing further, I would like to once again thank. I'm repeating actually. I was not aware that I got disconnected in the meantime when I was speaking, and I went on talking. Though nobody could listen to me, I got disconnected. Anyway, I once again thank the organizers, the IQAC team, Principal Sir, and the Department of Commerce, and everybody who worked to make this seminar successful. And especially a big thank you to you, madam, for giving our students, our teachers, our colleagues a wonderful time and insight into this very interesting world of intellectual property rights, at least the legal aspect of it. Thank you. Thank you very much.
Thank you.
Thank you.
Thank you, sir, for the lovely vote of thanks. And thank you, ma'am, once again from all of us. We'll look
Thank you.
forward to host you again and again. Okay, looking forward to that. And I think, Pampati, are you there? I think we can
Yes,
close now,
I'm
right?
here.
Okay.
Yes.
Thank you, ma'am. And
Thank you, ma'am.
with due, and
Okay,
with due
thank you,
respect
ma'am,
to all my
for
colleagues,
the.
so we are
Okay,
closing.
yeah.
Thank you.
Yes, Pampati.
Yes, thank you, ma'am, for your stimulating speech. Yes, I just felt that as if you were speaking directly to me, not in an online mode. It was so lively. Thanks a lot for that. And I think everyone enjoyed it thoroughly and again get benefited from it. Maybe we will meet sometime later and organize some offline seminar, and we will meet again also. Okay, thank you very much.
Definitely. Thank you. Thank you.
Thank you everyone for attending the seminar. Okay, so now I'm just closing the session. Okay,
Thank you. Thank you. Okay.